Welcome to Voices and Views. Today I will be discussing one of the effective ways of planning your estate. That is by creating a trust. What is a trust? It is an arrangement whereby an individual called a settlor transfers his assets to another person called a trustee for the purpose of carrying out an object for the benefit of named beneficiaries. So for a trust to exist, there must be an effective transfer of the assets from the settlor to the trustee with clear objectives. This relationship is regulated by a document called a trust deed. Unlike a will, a trust becomes operative in the lifetime of the settlor. Once a trust is properly created, in the eyes of the law, the assets, subject of the trust, no longer constitute part of the estate of the settlor. So, a trust effectively pauperizes the estate of an individual such that when he passes on, those assets no longer constitute a basis for disputation amongst the settlor's relatives. So let me put it in perspective. There are certain customs that deprive women and girls from inheriting property. There are also some classes of assets that can only be inherited by male children because of the strictures created by custom. The wills law stipulates that the owners of such assets must comply with the applicable custom before bequeathing them. Otherwise, that particular bequest will be declared void. The property owner will only be bound to comply with the wills law if he decides to bequeath such a property through a will. As for a trust, the need to comply with whatever custom says is completely non-existent. So, what are the advantages of a trust over a will? Confidentiality. When a will is read, it becomes a public document. Anyone can apply for a copy of a will. Anyone can apply for a certified true copy of a will. A trust, on the other hand, is not exposed to public scrutiny. Payment of taxes. As for a will, in order to vest the properties in named beneficiaries, the executors are obligated to pay a percentage of the value of the asset to government. This payment is called estate tax. A trust becomes operative in the lifetime of the settlor, so it does not have to go through the rigors of probate, and it completely obviates the need for payment of estate taxes. Flexibility. A settlor is able to dictate the management of his assets in his lifetime, and the trustee through a revocable trust. I hope you found today's episode enlightening. In our subsequent episode, we will be discussing further on other ways to manage and distribute your assets. See you then.